Lord, under under the selection process, Lord, judicial selection process. 2006 9 SCC, page 507. Malik Mazdur Sultan versus UPSC. Lord, your lordship may come to paragraph 2, page number 3 or 509. Lord, the main question to be determined in these matters, which relates to the recruitment to the post of civil judge, junior division under the UP Judicial Service Rules 2001, is also to the eligibility of some candidates from the point of view. But the controversy which arose in that case was, but suppose if recruitment has taken place in that particular year.
All right. Which para you really? What is the?
But I just wanted to bring it to a short.
What is the ratio?
Ratio, not. Blood, your lordship may come to page number 13. Para 13.
Yeah.
The question is to the interpretation of rules framed in exercise of power conferred under Rule Article 234, the proviso to Article 309 of the Constitution upon the governor of Uttar Pradesh in consultation with PSC. But this is the thing. Your lordship may come to page number para 21, 512, para 21.
Advertisement issued with the exam.
Undoubtedly, the excluded candidates were eligible age as per the advertisement, but the recruitment to the service can be made only in accordance with the rules. And the error, if any,
we accept your principle.
Look, here the basic contention of the government as well as the TNPC is that we have gone by the advertisement. Look, the advertisement cannot supersede the rule. The rule stands as such. One more thing, your lordship may come to, there is a judgment, recent judgment of the Supreme Court, Lord, in 2019, 15 SCR 273. The primary contention of the respondent is only one fold, my lord. The usual astra.
This they have referred. Mr. Ravachari referred.
The usual plea. The usual plea which is taken always by the government once we take part in the selection process. But once you have taken part, you can't question it.
No, that is not the universal principle. We are not saying so. How many selection petitions are pending before that?
Your lordship,
that is not a universal principle.
I'll just refer it to your lordship.
So the judgment was referred by Mr. Ravachari.
Yes, I'll just refer it to your lordship and leave it to your lordship. But the preliminary objection, paragraph number 30, not at 286.
Yes.
286.
Yes.
On the other hand, the learned counsel for the respondent questioned the maintainability of the appellant's challenge and urged that once a candidate had participated in the recruitment process, he or she could not at a later stage challenge its correctness merely because of having failed in selection. It was contended that the appellant was taking 2 shots at success. Her challenge was opposed for being opportunist. Your lordship may come to for that answer at page number 288, para 18. However, Lord, after cutting off judgments which was referred, Lord, your lordship may see page paragraph 18. However, we must differentiate from this principle insofar as the candidate, by agreeing to participate in the selection process, only accepts to the prescribed procedure and not to the illegality in it. In a situation where a candidate alleges misconstruction of the statutory rules or discriminating consequences arising therefrom, the same cannot be condoned merely because the candidate had taken in it. The constitutional scheme is sacrosanct and its violating of any manner is impermissible. In fact, a candidate may not have a locus standi. Your lordship, non-suited Mr. Subramaniam on the ground, because he has not taken part in the selection process. That is the reason your lordship yesterday your lordship dismissed the impleading petition.
You are not dismissed. He said that you can't so much argue on that selection process because you are not participated.
That is the reason, Malad, because I've taken part in it. That is the reason I'm bringing it to your lordship notice.
See,
The
can you
rules.
imagine a candidate who has not even participated is questioning the provisional selection list with a futuristic idea.
Lord, I
we
accrue-
noticed that. We
Lord,
noticed
a
that.
candidate accrues his right only when he participates in the selection process.
That's all we said.
That is all. But that law should be made clear. Your lordship may see the act stands. The executive instructions cannot override the act.
Correct. We'll consider.
The advertisement cannot be in violation of.
Yes.
And for one of
Because same counter
general term candidates, Malad,
One of the.
general term candidates,
Ah.
14377 of 24. This candidate, Malad, she comes in the 42nd rank. She has obtained 284 marks. In the earlier list, Malad, she found a place. The subsequent list, she was excluded. Malad, even leaving aside the case of Shobana or your lordship decision in Sheena, whether for the current year vacancy of 153, 31% of reservation is to be given to the general turn category, 31% for general turn. It comes to 47.
That is not reserved for.
That is, yes, I am with your lordship. 47 seats for general turn out of 153. She acquires the 42nd mark, the 42nd rank, 284 marks. She has been excluded. Neither in the counter filed by TNPSC or by the government. They are not given any reason for that. Surprisingly, my lord, there is one candidate who belongs to the ST community and comes under the PSTM. He has been accommodated in the general turn category. But Mullahs, out of the 245 vacancies, 5 vacancies have been carried forward. Of the current year vacancy, 5 vacancies have been carried forward because no suitable candidates were found. Out of that, 1 seat goes to Mullahs, the ST candidate who comes within the PSTM. Your lordship may take the counter of TNPSC in 14377 for a moment. That they admit.
But that is why we are not, we are not redoing the entire, we are not called upon to undo the exercise done.
Indeed, Malaj, but the TNPSC admits that out of
Anyhow, we'll ask them to look into that. We'll ask them to look at that. If that is the case,
Note of that, it is 143.
yes, we will ask them to look at it.
Paragraph 14 of paragraph 14 of the counterfeited filed in 148.2 of 2000. Your lordship may take note of it.
I adopt.
Ah, yes.
It's the last page, my lord, 70, page number 70.
Madam, you want more transparency, it will be ensured, don't worry.
Mark list, we don't give date of birth, that is not necessary at all. Now, what is the petitioner's real?
They are contemplating their own
It
procedures.
is on the merits we publish. It is only on the mark. But that is why counseling. This year, there is a specific clause.
Yes, we'll consider that. That is not.
I have filed a counter saying why to make. We are on a larger issue. They want not all persons mark. Only to challenge.
நீங்களே பொறுமையா இருந்தா நாங்க என்ன பண்றோம்?
I will.
இவ்வளவு நேரம் கேட்டுக்கிட்டு இருக்கேன். Always Bharnidharan is very quiet. அவருக்கே பொறுக்க முடியல சார்.
We are dealing with the.
Normally he will be very calm and composed.
Sorry.
அவரு இல்ல. We are realizing the situation. அப்ப எந்த அளவுக்கு அந்த பாயிண்ட் போச்சுன்னா உங்களுக்கு அவ்வளவு கோவம். Yes, anyhow.
I will.
We'll consider, madam. We'll consider. See, madam, one thing you have to realize, you can't go beyond the scope of the legal issues formulated. That is why he is little irritated. See, if you go beyond the scope and say, publish this and that, we are not, we are exercising only in respect of Rule 27F. That's all we are called upon to do so. It is not the entire selection or how you should prepare the list, this and all. That is not the point. Yes. That will consider. That is not a good ground to quash the entire selection.
I will add.
எல்லாத்தையும் கொடு. எல்லாமே கிடைக்கும்.
At the petition, appeal has been filed, now let them fight it out. Not in this.
Yes.
I will add one thing. The 27F, third proviso, challenge the constitutional and validity of the act, which was came to the before the honorable the first bench of this honorable court. on 8/2/2022, my lords, in WP number 1900 of 2022, this honorable court, my lords, dismissed the, my lords, the writ petition. Uphold the, my lords, the provision. I
Yes.
filed the additional typeset, my lords, which was in.
No, no, all right. 27F remains in this, it remains in force. We are not questioning. Yes, Mr. Ravi, you want to, you are for unselected candidate or? Huh? So then you are going along with the advocate. You are for unselected.
It's a slightly different issue, but I will request my senior to at least not wait for at least one day, so that let this issue be completed.
I will hear you, sir. Yes.
Therefore, that issue.
Let all, we will not confuse all those issues. We'll complete this. We'll exclude, no problem. We'll exclude.
No, no, but even Lordship may have it.
Tomorrow we'll do it.
Tomorrow, day after tomorrow, Lordship may have to.
No, even tomorrow.
Yes,
No. Will, no, yes. Yes, yes, TNPC, Bharani, you want to say, sir? அவருக்கு மட்டும் நாளைக்கு போகும்.
Even though I would normally have liked to begin first, on behalf of the state. In this case, what I will do is there are about 4 or 5 councils who want to do supporting arguments. Let them complete their turn first, so that I think that your lordship is rising at 3:15 to.
No, we are not, we are continuing up to 4:45.
Oh, today.
ஆமா. அந்த பெஞ்சு கேன்சல் பண்ணிடுங்க.
Oh.
இத முடிக்கணும்.
அப்படின்னா right.
ஏன்னா அது வந்து 330 மேட்டர் வந்து ஓல்டு மேட்டர் 10 வருஷமா பெண்டிங்கா இருக்கு. அப்புறம் இது இட் இஸ் வெரி இம்பார்ட்டன்ட். அதனால அதை போஸ்ட்போன் பண்ணி சொல்லிடுங்க ஜெயக்குமார்.
Let them all finish. I'll come in about half an hour.
Yes.
I'll get the judgments then. We'll print out at the.
We'll complete it today.
Yes,
Yes.
that's
Because this issue cannot go on for. Yes. சொல்லிட்டேன் நான் ஃபோன் பண்ணி சொல்லிட்டேன். நான் சொல்லிட்டேன்.
I'll do something.
நான் சொல்லிட்டாரு. நானே ஒரு ஃபோன் பண்ணி சொல்லிட்டேன். அது ஓல்டு மேட்ரு. அவரு அதான் சொன்னாரு. அவருக்கு சார் லாஸ்ட் டே ஏதோ முடிச்சுட்டு ஊருக்கு வர process of winding up.
Yeah, just, then I can quickly finish my thing fast. I don't have to wait for that. Blood, few facts will have to also be set out because everybody started straight away on a question of law and Shobhana's case and all that. But the TNPSC notification was issued on 1st of June 2023, notifying lot 245 posts of civil judges. Of this, 92 were carried forward vacancies and 153 were regular vacancies. But out of that 92 carried forward vacancies, PC general and 7 not PC Muslim.
Yes.
Totally, my lord, the preliminary exams are conducted on 19/8/2023. Out of that, blood.
1:10.
Yes, that's the ratio normally followed. Out of the 12,500 candidates, 2,450 were called for the final examination, which was held, my lord, on 4th and 5th of November.
Called for main exam.
For the main exam, 2,450 were called, which was held on 4th and 5th of November 2023. The oral tests were conducted, my lord, between 29/1/24 and 10/2/24.
Yes.
And the first selection list was published on 16/2/2024. This selection list was challenged in WP number 5105 of 2024. And your lordship, lord, passed orders allowing that repetition, holding that in view of the judgment of the Supreme Court in Shobhana's case, before taking up the backlog vacancy, you would first do the GT turn, complete it, then go to BC, the backlog, then go to regular reservation for the current year, with the turns normally following. But this was challenged in the SLP, and the SLPs were withdrawn on 22/3/2024. But even before the withdrawal of the SLP, certain candidates who were aggrieved by the orders passed by your lordships, because they will go out, about 16 of them. They moved a review before your lordships. Lord, the more important point of the review is that the grounds taken here regarding Shobana, regarding whether Lord it is per incuriam, whether Indra side has a different perspective, whether the backlog agency should fix first, whether the TNPS first notification was right and not the subsequent stand we are taking now. Every one of those notes have been raised in the review, and every one of those notes has been taken up by your lordships, by your lordships order dated 7th of March 2024. Your lordships dismissed that review. With that, according to my respective submission, this entire issue attains a finality, subject only to any interference by the apex court, which is not there in this case. Consequently, on 19th of March 2024, the final revised list was published, strictly applying the law as laid down by your lordships in your judgment dated 27th of February 2020. That list has now come to be once again challenged by the very same 16 people.
Yes.
Two grounds. First ground is please don't apply Shobana. Apply only the TNPSC's original notification,
Yes.
because that is only correct, because otherwise your the thrust of their argument is otherwise. If you apply Shobana in the way it ought to be done, the actual reservation will far exceed 50%, and therefore it's again violative of Article 16. The second argument was, in respect of the third proviso to 27F, you could not carry forward the backlog vacancies at all in respect of these. But I will deal with the first argument first. In that respect, my respective submission is that firstly, it is impermissible for a High Court to declare a Supreme Court judgment per incuriam. Even if it be a obiter, that is the extent to which the Supreme Court has gone. I had cited before your lordships in the review case itself that judgment of the Supreme Court, where they say even an arbiter of the Supreme Court may be binding on the High Court. You can't declare that to be per incuriam. That being the case, that entire judgment arguments based on the fact that Shobana has ignored anything is goes. Secondly, in Shobana, reason why your lordships were with great respect right and apply Shobana, it is not as if Shobana has not noted Indra. Indra is referred to. Indra, the series of judgments following Indra, Nagaraj, every one of us is referred to. Therefore, there is no question of Shobana being bad law. Secondly, this entire petitions amount to relitigation. Relitigation has been frowned down upon by the Supreme Court, and your lordship saying you cannot keep coming back on the same list again and again and again. I will be not also circulating that judgment on relitigation, saying that it goes against the grain of judicial administration.
Which paragraph?
The lordships will kindly take the Supreme Court judgment in KK Modi versus KN Modi. Lordships will straight away take paragraph number 43, where they deal with this relitigation concept.
Yes.
From 42 itself, I will take it.
Yes.
The Supreme Court, para 42, the Supreme Court practice 1995, published by Sweet and Maxwell in paragraph so and so, explains the phrase abuse of the process of the court. Thus, this term connotes that the process of the court must be used bona fide and properly and must not be abused. the court will prevent improper use of its machinery and will in a proper case summarily prevent its machinery from being used as a means of vexation and oppression in the process of litigation. The categories of conduct rendering a claim frivolous, vexatious, or an abuse of process are not closed but depend on all relevant circumstances. And for this purpose, considerations of public policy and interest of justice may be useful. One of the examples cited as an abuse of process of the court is relitigation. It is an abuse of the process of the court and contrary to justice and public policy for a party to relitigate the same issue which has already been tried and decided earlier against him. The re-agitation may or may not, this is important, may or may not be barred by res judicata. But if the same issue is sought to be re-agitated, it also amounts to an abuse of the process of a court, a proceeding being filed for a collateral purposes or a spurious claim being made in a litigation may also give rise to a given set of facts. Frivolous or vexatious proceeding may also go. So it may or may not even amount to res judicata, but still if it is between the parties, it's done. The mistake, if I may use the word loosely, they did was they did not come on review before your lordship and invited the binding. They could have filed a third party SLP directly to the Supreme Court. Whatever Supreme Court might have done, might have been done. Their arguments that I was not heard, etc., all lost its meaning the moment they came before your lordship and got a hearing. Now the review order has become final. Therefore, then at that point of time, in respect of those 16 candidates, vis-a-vis this list, it has attained finality. And this will amount to a re-litigation, which will be an abuse of process of court as per the Supreme Court statement. The other point which is important, my lord, this I'm raising it as a first plea. I'm also going to satisfy your lordships that the backlog vacancies can continue. Nothing wrong with that. The doctrine of constructive res judicata has been held, my lord, by the Supreme Court to apply even to writ proceedings. This, my lord, is in State of Karnataka versus All India Manufacturers Association, 2006, Volume 4 SCC, page 683. In that, specifically, their lordship deal with this in paragraph number 32 onwards. Res judicata.
Yes.
They went to the extent in this case of saying actual and constructive res judicata will operate even in PIL matters unless the subsequent petitioner shows that the first petitioner was not a bona fide litigant. So long as the first petitioner is also a bona fide litigant, constructive res judicata even applies to PIL. Section para 32. Res judicata is a doctrine based on the larger public interest and is founded on two grounds. One being the maxim, no one should be vexed twice for the same. Secondly, public policy that there ought to be an end to the same litigation. It is well settled that Section 11 of the CPC is not the foundation of the principle of res judicata, but merely a statutory recognition thereof, and hence the section is not to be considered exhaustive of the general principle of law. The main purpose of the doctrine is that once a matter has been determined in a formal proceeding, it should not be open to parties to re-agitate the matter again and again. Section 11 CPC recognizes this principle and forbids a court from trying any suit or issue which is res judicata, recognizing both cause of action estoppel and issue estoppel. There are two issues that we need to consider. One, whether the doctrine of res judicata as a matter of principle can be applied to PIL, and secondly, whether the issues and findings and so on so says constitute res judicata for the present case. That would be on merits. They go on further to say that unless the PIL litigant was not bona fide at the first instance, even for PIL it will apply. Para 36 deals with actual and substantially in issue and also deals with blood. We will presently consider whether the issues and findings, they extract explanation 3 to section 11. The matter above referred to must in the former suit have been alleged by one and either denied or admitted expressly or implied by the other. The explanation 4. This is more important. This is constructive res judicata. Any matter which might and ought to have been made a ground of defense or attack in such former suit shall be deemed to have been a matter directly and substantially in issue in such suit. The spirit behind explanation 4 is brought out quickly in the words of Viscount Vikram in Henderson versus Henderson. But they have extracted the entire thing. And their lordships will not extract two more judgments. And at paragraph 40, they talk about the judgment of the Supreme Court in the direct class 2 engineer officers association, which is the most quoted judgment on
Yes.
adjudication is conclusive and final, not only as to the actual matter determined, but as to every other matter which the parties might and ought to have litigated and have had decided as incidental to or essentially connected with subject matter of the litigation, and every matter coming into the legitimate purview of the original action, both in respect to the matters of claim and defense. Thus, the principle of constructive res judicata underlying explanation 4 to section 11 of the CPC was applied to writ cases. We accordingly hold that the writ case is fit to be dismissed on the ground of res judicata. Not you may not even have to go to anything else, because every one of these parties, when they moved the tribunal before your lordship and sought to agitate this list, ought to have taken every ground that was available to them. They cannot take it in peacefully, just to avoid litigation. That is the point. But now, on merits itself, the point I would like to make in respect of the continuing the backlog vacancies for PCs is it is done not because of any provisions or prohibitions not contained in the Tamil Nadu Act, Service Act. It's because of the mandate contained for the state by Article 16.4. Article 16.4, according to my respective submission, is not an exception to Article 16.1 as was originally thought. It is much more than that. 16.4 is a substantive provision which has been brought into the Constitution, which mandates the necessity of equalizing unequal people.
Social justice.
Exactly. It is part of a larger social justice. So the original concept that 16.1 is the main constitutional provision and 16.4 is only an exception provided is not correct.
That is carved out to meet out the preamble.
Exactly. Exactly. There, 16.1 says there shall be equality of opportunity. So not 16.1. There shall be equality of opportunity.
Yes.
For all citizens in matters relating to employment or appointment to any office under the state. Now take 16.4. Nothing in this article shall prevent the state from making any provision for the reservation of appointment or posts in favor of any backward class of persons, which, in the opinion of the state, is not adequately represented in the services under the Act. Then the 4A is relating to promotion. 4B is post Indira Sani. That's very important. Your lordship sees 4B was inserted by the 81st Amendment Act of 2000. It says nothing in this article shall prevent the state from considering any unfilled vacancies of a year, which are reserved for being filled up in that year in accordance with any provisions for reservation made under Article 16.4 or 4A, as a separate class of vacancies to be filled up in any succeeding year or years, and such class of vacancies shall not be considered together with the vacancies of the year in which they are being filled up for determining the ceiling of 50% itself.
Here, interestingly, this 4B
Yes.
permits the state to notify carry forward vacancies. Carry forward vacancies. So it is a reserved vacancy.
Yes.
It is nothing to do with the general term.
Correct.
It is nothing to do with the general term. So therefore, the rights accrued
Under
4B
can never be taken away by anything.
cannot be. It is a constitutional right.
Constitutional.
Fundamental.
Exactly.
It is fundamental.
It's a fundamental.
Fundamental right. Therefore, it is to be tagged along with the principles of social justice, number one. Number two, the rule says at the first instance it's to be filled. Why? Because that vacancy should not again fall as a carry forward vacancy. One aspect. So current year vacancy, if there is no eligible candidate, then that can be carried forward again. Correct? That is why. More so, their analogy is reservation goes to 80. That is their analogy. It may go to 100 tomorrow.
Can go to one.
Then it is a good sign. Why? Because as morning Mr. Balan also slightly said, we'll be meeting out a casteless society.
You are looking at the entire law.
Yes. Therefore, the BC will become forward at one stage. The
The-
BC will become forward.
the
It may be 100 years or two, we don't know.
And the ulta will not happen in social justice.
Exactly.
They will remain where they are.
Therefore, in those circumstances, there is a possibility of removing reservation, which is the constitutional, one of the constitutional perspective.
It is in the long run, if you want reservation to completely go, you will have to give full impact to 4B.
That is why it is relatable to social justice.
Absolutely.
That is why now it is 80%. Why? Because there are more number of BC meritorious candidates.
All the time. All the time.
All the way. So many of the BC communities are not really backward. So they have come up.
We go for a
Statistics.
social service status survey,
It is a different
it will be
view.
a different.
Therefore, tomorrow, if it reaches 100, then policy may change. Policy may change.
Some communities which are in the BC right now will also go up to power. Some communities which are in SC may come to BC.
BC. Exactly, it will happen.
The idea is that it
So-
should progressively keep going up.
This exactly is the constitutional philosophy or goals.
Right. And the crucial point is when they are all talking about Indira Sahani all the time, 16(4)(b) as a constitutional amendment was made post Indira Sahani.
For that is the reason why we also independently considered that while first
Yes.
judgment, while applying
Yes.
Shobna, we have made a paragraph, we have independently gone into general TAN vacancies cannot be mixed up with the backlog vacancies.
Correct.
Because it takes a constitutional seat. That backlog vacancies takes a constitutional seat and therefore it cannot be mixed up with the general candidates. And the social justice require that the meritorious candidates and their merits are undisturbed and backlog vacancies are filled up at the first instance by fitting in those reserved category.
After in a case like this, after you have already done the merit list first in the total. Just like in Shobana's
So
case.
that is why it requires an interpretation. 27F requires an interpretation. The word first,
Be consonant with 16(4)(b). That's the.
the
point.
word first, the word first.
That is what.
See, it is not as if a straight jacket formula is adopted while interpreting the word first. The word first must be relatable to 4B, capital 16 capital 4B, along with social justice.
Exact.
Yes.
Exact. That is the sum and substance of it.
No, we have not gone deep into that because it is not, may not be required. Because again, here sitting in a high court and giving a constitutional interpretation may not be required.
Constitutional court.
Huh?
Being a constitutional court, we have to.
No, we have to do, but in this case, it may not be required. Yes.
So according to me, Milord, the mandate
Or
of
a ground theatre. Ground வாங்கலாம்னு பாக்குறாரு. நாங்க உஷாராதான் இருக்கிறோம்.
what fell from your law
அதான்.
is the words of the Supreme Court. It's a constitutional duties of the Supreme Court.
Yes.
That is Milord M. Venkateswarlu versus Government of Andhra Pradesh, 1996, volume 5 SEC, page 167. And this is specifically in the context of backlog vacancies. Your Lordship should take paragraph number 10. It would have lapsed as per the act in Andhra Pradesh. This is what their Lordship say in para 10. In this case, the appellant fell short of 5 months service for purpose of period of 2 years as a senior assistant and of 1 year 5 months for the purpose of total service of 8 years in revenue. In view of the huge backlog of reserved vacancies on account of non-availability of SC and ST tribe candidates, the government appears to have intended to relieve the injustice to the appellant by relaxing the prescribed period of service under Rule 8(2) read with annexure. It is not in dispute that the appellant had passed all the prescribed tests well within time. The only eligibility was as regards the completion of the required period of service. It is settled law that the government cannot relax the basic qualification, but in an individual case, that it can relax in an appropriate case the conditions of service. It is seen that the appellant having passed all sets, he was required to fulfill the condition of total service of 8 years and minimum service of 2 years as assistant. Therefore, with a view to fill up the backlog vacancy, which as rightly pointed out by Sri P.P. Rao, undisputably is a constitutional obligation. The government appears to have exercised the power under Rule 47. Those who went against it, relaxed it.
What is exactly is the reason age relaxation given?
Yes.
Some relaxations are given, enabling those reserved candidates to compete with the meritorious candidates.
Exactly. Idea is not to throw out the backlog vacancy. The idea is to fill it up.
It is to bring balance.
Exactly. But according to my respectful submission, therefore, 27 will have to be read in the conspectus of 16(2) as well as 16(4) and 16(4)B. And if that is done, the present list would be correctly falling within the ambit of it.
Nicely presented. In short. Yes, come, yes.
I was worried in the judgment printout வரல பயந்த எடுத்து வச்சிருந்திருக்காங்க.
அது நீங்க ராவாச்சாரி சார் போட்ட ஜட்மெண்ட்டை மட்டும் பைண்ட் எடுத்துடாதீங்க. அவர் இவ்வளவு கொடுத்துட்டாரு. One stage we told 1950 onwards you have produced all reservation case judgments, it would be very difficult. ஆமா.
Being with the tide. Winning against the tide.
ஆமா.
But I would really request Raj and learn a path with GO 34 and 9.
அதெல்லாம் நீங்க எப்ப வேணா அதெல்லாம் நெட்லயே இருக்கும், நீங்க வாங்கிக்கலாம்.
They rely upon the counter.
We are not relying upon that. They let them rely upon so many things. Why we are not relying upon total?
Should not be able. See, get the direction of the website.
Constitutional principles are not decided by affidavit and counter affidavit. It's not decided on counter affidavit.
High Court. சொல்லுங்க. Yes.
Primarily on legal, but they are not being heard in the previous petition. The model of pathway.
Not implemented, not implemented.
Secondly, general and vacancies are filtered. General backlog vacancies are filtered. Exceeding the 68%.
That is addressed by the advocate. That is addressed by advocate.
Against the purpose of Article 16(4)B and against the plain and natural meaning of Section 57 here, third provision. That is the three legal challenges have been faced. For my respectful submission, Lord, as far as the application of Section 27F is concerned, but it does not apply to a situation in respect of selection based on this. That 27F would only come into operation post selection based on merit. That it would only apply in respect of methodology for applying the reservation. But there are three methodologies to be applied in a case of selected person. First, in the general term vacancies have to be filtered, followed by the backlog vacancy. Third is the current vacancy. Petitioners do not have the argument before the Honorable Court based upon the clause contained in the notification and the rationale employed in 27F. First, please resorted to backlog vacancy and then resorted to the current vacancy as per the distribution of those. But 27F does not even deal with the situation where a selection is based on merit. So therefore, attempting to interpret Section 27F as if it postulates the situation covers for a selection based on merits on general or other.
That is why it is a totally different. Common competitive exam is different.
Yes.
Application of 27F is different.
Exactly.
Selection is common. So applying the reservation rule is different.
That is the method. Because
That is what we have adopted in the first instance.
Yes.
That is what we have adopted.
They consist of reserved category candidates also. Because there is no logic at all to fill up all these reserved category directly into the backlog vacancy based upon a roster, because it would not actually defeat the purpose of merit. Rather, your lordship has applied the case of law. In so far the rank holder demarks your respective reserved category, please occupy the general term.
1 minute. Yeah.
Please occupy. So lordship has issued a directive. So irrespective of the reserve category, if you are a top ranking holder, please occupy the general term vacancy, because the person stand in the next line of the recent reserve category would occupy the respective reserve category. Well, that is what your lordship said. Right? In fact, the distribution list itself will both in the backlog vacancy and the current vacancy. Your lordship has directed the TNPC first to please carve out the TT vacancies, fill up, and thereafter go to the backlog vacancy and current vacancy.
That is how the word first is interpreted.
This analogy or methodology is adopted. It would rather provide much more opportunity to the persons who are in the below ladder, so that though I belong to a reserve category, if I occupy a TTC, while a person standing next to in my category would come forward in the ladder, he will occupy the reserve category. So therefore, it rather advances the social justice. That is my question. But secondly, as well as after your lordship judgment in the writ petition, majority leave writ petition, that is 966, 7 of 20, totally more than 10 writ petition. Out of that, 3 writ petitioners have already filed a review application with the Limo's order report. My answer, again, will not reiterate the position in JP case. My respectful submission, doctrine of merger of government, because of the dismissal of the review petition, the order passed in the review petition have not been appealed before the Honorable Supreme Court. What has been challenged before the Honorable Supreme Court is the first order passed in illegalities. So therefore, my lord, your lordship's order pursuant to review order got questioned. So therefore, my lord, questioning the correctness or my lord, the binding nature of the pre-judge decision of the Supreme Court. My lord, I don't think, my lord, that can be handled before lordship. That is legally impermissible. Secondly, my lord, there is only one submission, though it is purely academic. Because what is not to be assigned to lordship? But the Governor case was correctness of the decision of Governor was assigned solely on this law. What is that? In K. Raja, that is the judgment of decision of this honorable court, and my lord, Ramesh Properties. These two decisions were relied upon. So as we say, the judgment of the K. Governor case is fell into it. But my respectful submission, first decision K. Raja is a case not relating. While fixing a seniority, roster to be applied, rank to be applied. So therefore, it is a proposition for that principle, whether a roster-based seniority to be applied or the rank-based seniority to be applied. Secondly, Ramesh Properties, meritorious sub-category candidate. In the state of Tamil Nadu, after K. Raja, following the jurisdictional work, all selection lists were revised, saying that it is a rank-based seniority. And one more logic is also thought to be argued, though it is an, I will place it as an analogy. But suppose, my lord, if the argument of the petitioners are to be accepted, irrespective of my category, first fill up the backlog and then go to the current. But prior to interpretation of sober law, in the state of Tamil Nadu, position is this. Though there is a common example of backlog vacancy and current vacancy, there is a two distinct groups. Therefore, my department were usually issuing two seniorities. Person who occupy the post in the backlog vacancy will be a senior to the person who occupy the post in the current vacancy.
ரொம்ப குழப்பாதீங்க. நிறைய குழப்பீங்கன்னா கஷ்டம். We are not called upon to decide those issues. That is the resultant consequences which we need not look into. Sir, we are not called upon to undo the list or redo the list. We are not called upon. We are called upon to interpret that certain provisions. That's all. அது சுப்ரீம் கோர்ட்ல பெண்டிங்கா இருக்கு, அங்க பாத்துக்கலாம். No, that is that is what we say. Application of reservation is one aspect. Number of candidates selected from the reserved candidate is different. Simple, I'll tell you. 100 vacancies, 90% belongs to reserved categories or selected does not mean that reservation is 90%. What actually the reservation indicated as per the notification must be given based on the ranking. But the reserved candidate getting a seat in the general turn, it cannot be construed as a reserved vacancy. இதை நீங்க சுத்தி சுத்தி குழப்ப வேண்டாம். Tomorrow, take a scheduled tribe community candidate, ranks top in the list. He will be a general turn candidate. He will not be a scheduled caste tribe candidate. Therefore, one may say he will be in general turn, but in a post reserved for AC, another candidate will. This is how the social justice works out. Otherwise, what will happen? Always it does not mean only scheduled caste means only 18% alone should be appointed. 18%, 100 posts. 18% alone should be appointed. They are entitled to compete on merits along with all other candidates. So their merit is to be ranked as it is. If they are meritorious and if their ranking is number 1, they will come under the general term. Simple. அதுக்குள்ள போவாதீங்க. Yes.
Already negative and sober.
6980 வந்து it is based on the number of candidates. Number of candidates selected. That is what we said. I said to senior counsel Raghavacharya. Then tomorrow it may be 100%. Who knows? It may be 100%. No, that is not the point to be considered. That is not. We are not concerned about whether all the 32% reserved for general turn is occupied by other caste people, or all the 32 is occupied by BC, all the 32 is occupied by SC. We are now way connected. Tomorrow, general turn candidates, general turn percentage is 32. General turn means it can be occupied by any person. That's all. Very simple. Therefore, we are not worried whether all the 32 is occupied by OC, or all the 32 is occupied by BC, or all the 32 by S. We are not concerned. Because that is only based on merit. All right. Yes. Everything covered. Your duty is to ensure that you should not allow us to sleep. That is the only guarantee you must give.
And not another different principle by as well as the current council of being around decided. There is a principle it says that even if you have participated in the proceedings, you can challenge the notification if it is not there is an illegality. For the commitments now very clear. The notification, internal pay 3, read with internal pay 34 months, clearly provides for carrying for vacancies. Notification is not at all under challenge here. Not all those inputs are whether you can challenge the notification or not. Here the notification is not under challenge at all. So therefore, the notification when it's not challenge, what is to be tested here? I am afraid not what there's nothing to be tested here. Now we not if anyone says these are the challenge to the notification, we can take a plea that cannot say government orders not overriding the act. Then we not another plea whether the act is constitutional. Whether we not answer that is why the government has now come forward saying that we are going to amend the provisions of the act. Therefore, now when notification is not under challenge, I think need to be concerned that they have participated in the proceedings. There is no challenge at all. Therefore, nothing to be tested as well. And with regard to whether the first list or the second list, you are not very clear. Now, these all carry for vacancies or vacancies. In the initial selection,
92 vacancy carry forward.
92 vacancies carry forward. So, not use the welfare side is not because the other program is now they cannot even not the logic said it is improper not to say when the illegalities, get it wrong. Not wanted to see was all these 92 carry forward vacancies.
Because that was the argument even at the first instance placed by Mr. Subramanian.
Yes.
He is not here. But yes, that was the argument placed.
Only recommendation against be considered first. That note is 92 vacancies, if it had been considered, the persons were eligible, were there. They would have waited till the regulation takes place. Merely because it has been carried forward to the next selection, would not mean that merit can go, it can be given a go. Therefore, it is very clear. So therefore, without that, now the situation has been settled. Now, one is not liberty, it is not under demand. Once they are offered, they said, there is offer from the London Council, whatever reason they may be, they have not expressed to the Honorable Supreme Court. There the list has come. Secondly, we'll go there and challenge the second thing. All your lordship's orders are intact. There is no reversal. It is not a demand. Lordship did not say you again reconsider the issue. Therefore, nothing will be created. That is my suggestion.
Anybody wants to say anything, can say.
Want to adopt the arguments of AG.
Yes, enough.
That's about, I think.
That is sufficiently available, not. Yes.
That's is to direct totally 32 vacancies of the BC carry forward vacancies. It's illegal. That's it. That was the specific question asked to the government. Whether the 32 vacancies of carry forward vacancies of BC is legal or illegal. That's it. Let us give an answer. 32 vacancies of carry forward vacancies of BC candidates.
சார் நீங்க உங்க கேஸ பிரச்சனை அவங்கள ஆன்சர் பண்ண சொல்லுங்கன்னு நாங்க சொல்ல முடியாது. அவர் ஆன்சர் பண்ண சொல்லுங்க, இவர் ஆன்சர் பண்ண சொல்லுங்க. தட் இஸ் நாட் அவர் ஜாப். நீங்க அப்புறம் இதே மாத்துறீங்க.
லாஸ்ட் டைம் கொடுத்தீங்க அது வந்து என்னன்னு சொல்லி
அதான் நாங்க எப்படி சொல்ல முடியும்? எங்க வேலை அது கிடையாது. உங்க பாயிண்ட் என்ன மாதிரி அவரை நீங்க ஆன்சர் உங்களுக்கு ஆன்சர் பண்ணுங்கன்னா நீங்க ரெண்டு பேரும் வெளியே தான் ஆன்சர் பண்ணீங்க. இங்க உட்கார்ந்துட்டு நீங்க சொல்லுங்க, அவங்க ஆன்சர் பண்ண சொல்லுங்க. if the court raises any doubt, they have to answer. அவ்வளவுதான். நீங்க அவரை சொல்ல சொல்லுங்க. That is not the case. Yes, come. Ekman. Cut. Students